at setting the pace for post-COVID-19 justice system. The vital platform for virtual court proceedings already developed and being put to use by the various cadre of Nigerian courts have further underscored the commitment of the Nigerian judiciary in keeping the wheels of justice and development in motion. In a similar vein, the National Judicial Council issued appropriate guidelines for court sittings and related matters in the COVID-19 era. These guidelines have been adopted by the hierarchies court, including state high court, in issuing practice directions that enabled the effective and innovative application of technological tools in the administration of justice in Nigeria. My lords, it is pertinent to note that in the wake of COVID-19 pandemic, economic recession, and the recent EndSARS protests, government in all these has ensured that fundamental rights of the citizens are protected and preserved through the setting up judicial panels of inquiry to investigate cases of alleged fundamental rights violation committed by the operatives of dissolved Special Anti-Robbery Squad and other units of the Nigerian police. The government has ensured that every Nigerian citizen has access to ventilate and protect his or her rights. Currently, my lords, not less than 26 states have set up their judicial panel, while the National Human Rights Commission has, on 17th of October 2020, set up an independent investigative panel to investigate the alleged activities of the dissolved SARS. As part of the federal government efforts in finding solutions to the demands of EndSARS protests, it is believed that the report of the panel of inquiry and effective implementation of their recommendations will meet demands raised in the protest. In further demonstration of government's commitment to addressing the welfare of the women and young persons, the federal government has constituted an Inter-Ministerial Management Committee on Eradication of Sexual and Gender Violence, SGBV. This is coupled with the government resolve to set up a special call for rape and gender-based violence. Further to the above, my lord, government has also equally embarked on programs aimed at addressing socio-economic challenges of her citizens through diverse modes of palliatives, like survival grants to household, monetary grants to small and medium-scale businesses, and soft loans directed at alleviating poverty in the nation. The federal government, through the Federal Ministry of Justice and its parastatals, and indeed other stakeholders in the justice sector, have made substantial progress in the reform of justice system, especially through the implementation of Administration of Criminal Justice Act of 2020 to achieve trial in criminal cases in Nigeria, and also promoting the increase of the domestication of Administration of Criminal Justice Act in the various states. Though through the relentless effort of the Attorney General, 31 out of 36 states of the Federation have domesticated the ACJA, with the listed being Imo and Yobe states that domesticated this year. The Ministry of Justice has also developed, first of its kind, a national policy on justice and securing the Federal Executive Council for the implementation across the country. We're also coordinating of the prosecuting agencies through the national policy on prosecution. This has led to the review of the prosecution of ongoing high-profile corruption cases to ensure speedy completion. The Ministry of Justice is under the Attorney General is also coordinating the anti-corruption efforts of the government and disposal of recovered assets. It will be recalled that I recently inaugurated the Inter-Ministerial Committee on Disposal of Assets forfeited to the federal government. It must be noted that the initiative was born out of the need for efficient management of stolen assets in line with the directives of Mr. President, following recommendations of Presidential Audit Committee on Recovered and Management Stolen Assets. It is heartwarming to recall recent boasts in the administration of justice through the appointment of the swearing in of a record 8 justices of the Supreme Court of Nigeria. It is our earnest expectation that this positive development, which is unprecedented in recent times, will significantly ease the workload of your Lordship and by extension, the court's docket. It is further expected that the consequential vacancies created in the Court of Appeal will be addressed in no distant time. On the financial autonomy of the state judiciary, the administration of President Muhammadu Buhari, GCFR, remains committed in ensuring that judicial and legislative arms of government across the 36 states attain financial autonomy in line with the provisions of Section 121, subsection 3 of the 1999 version thereto. I am delighted to state that a technical committee for the implementation of the financial autonomy has turned its report to the President. A full financial autonomy of the judiciary at the state level will strengthen the independence and capacity to deliver justice to all. The federal government, through the office of the Minister of Justice, has also commenced the process of introducing enabling laws to regulate our emerging digital financial subsectors of the economy. Presently, my office has commenced the process of resuscitating the electronic transaction bill currently dormant in the National Assembly and to initiate new executive bills aimed at stimulating the nation's economy. The foregoing will constitute a body of laws that will stimulate economic growth and enhance seamless integration of the national economy and propagate same into global digital economy such as Electronic Transaction Act, Electronic Evidence Act, Electronic Banking Act, and Digital Data Management Act. For this reason above, my office is now set to propose appropriate regulatory framework in consultation with Federal Ministry of Finance, Central Bank of Nigeria, and other relevant financial agencies towards providing the model base for consideration of the Federal Executive Council and thereafter National Assembly. My Lord, distinguished ladies and gentlemen, permit me at this junction to heartily congratulate the new senior advocates of Nigeria who have been sworn in today. I'm much delighted to rejoice with you, considering your years of toil and labor and painstakingly selection process through which you have emerged. As all this clearly stated, establish each and every one of you as deserving this prestigious rank. I therefore charge you all to remain the shining leading forces in the practice of law within and outside Nigeria. I must, however, reiterate that there are corresponding duties and responsibilities that go with your new rank and status. We are to kindly note that a senior advocate of Nigeria has an abiding duty to exhibit the highest form of decorum, discipline, and dedication to the cause of justice, which forms the basic of the legal profession. These you must at all times uphold. Further to the above, I am to note that as a leader of the bar and defender of the law, a senior advocate is expected to bring to bear on the profession high standards of diligence and honor in the preparation and conduct of his cases. In addition, be reminded that new status confer no immunity to disciplinary processes of our noble profession. I trust that you shall not be found wanting in the meeting of the demands of your new privileged status. As part of our ethical values, it remains the sacred duty of every lawyer to promote and foster the cause of justice and to maintain towards the court, not for the sake of the temporary incumbent on the judicial office, but for the maintenance of supreme importance. Judges, not being wholly free to defend themselves, are peculiarly entitled to receive the support of the bar against unjust criticism and clamor. In laying this support to this sacred duty, the Supreme Court, per Ogbuabu JSC, held in the case of Sali Dumade, 2010 6 report, and I quote, ensure that justice prevails at all times. I thank you for your attentiveness and commitment to promoting the rule of law. May God continue to guide and protect us as a nation. Signed, Abubakar Malami, Senior Advocate of Nigeria.
I recognize the Speaker of the House of Representatives, Mr. Femi Gbajabiamila, and the Governor of Rivers State, Mr. Nyesom Wike. Thanks for coming. I now call on the Chief T.J. Okpoko, Senior Advocate of Nigeria, to speak on behalf of the body of Senior Advocates of Nigeria.
My Lord, the Chief Justice of Nigeria, my Lord Justices of the Supreme Court, Their Excellencies, the governors, our governors and members of this profession, and governors who are not members of the profession. Please permit me, my Lord, to stand on the protocol we have very richly established. On behalf of the Senior Advocates of Nigeria, I welcome our new members and congratulate each and every one of them for scaling through the rigorous test in pursuit of this great honor. New members, I remind you briefly that the Senior Advocate of Nigeria remains a member of the Nigerian Bar Association and has to respect the organized bar and perform for the bar duties when called upon to do so. It has been said that lawyers who earn the honor of being Senior Advocates of Nigeria fall into a class of aristocrats in society. I therefore welcome these new aristocrats into the elite class of lawyers who have attained distinction in the practice of law. I remind you further that every honor has its own responsibilities, and I'm glad the Attorney General of the Federation has emphasized that speech. In every one of the special court sessions marking the opening of the legal year in the past 2 decades, our Chief Justice of Nigeria on each occasion took pains to give statistics of cases handled by the court in the course of the previous year. These statistics show that the number of cases getting to the Supreme Court's docket keep increasing from year to year. We listen to these statistics, but stakeholders do not appear to have given it thorough consideration because they convey a fundamental message. The message of the statistics from year to year shows that the docket of the Supreme Court is overloaded and that the justices of the court are overworked and overstretched. The speech of today confirms this statement. This is a trend that cannot be allowed to continue. If the nation is to get the full benefits which a Supreme Court of any country is expected to provide for its people. In a situation where the court is overworked, is overloaded, there is a certain likelihood that the standard of adjudication may become the victim of a system which overworks justices. The falling standard or falling standard referred to in the press and in dark rooms, in the intellectual quality of delivered judgments in our courts in the past few years, may have resulted from judges being overworked and overwhelmed by heavy workload of justices in the Supreme Court. In the case of the Supreme Court, the overloaded docket hardly leaves the justices sufficient time to reflect on their judgment after writing it or before reading it in open court. This stress and pressure on our justices is further aggravated by a new trend of some advocates citing myriads of judicial precedents where one or two may just be enough. In such circumstances, a hard-working justice is compelled to bear the burden of reading repeatedly within the short timeline available to him decisions, some of which may be entirely irrelevant in the case before him. Law is made by decision, not by a myriad of decisions. Stakeholders seem to overlook the fact that the human brain has its limitation. No matter how hard their lordships may work or attempt to work, overworked by reason of their docket, of their heavy docket, must impact the intellectual quality of their judgment. It is therefore right that conscious efforts be made to reduce the docket of the Supreme Court justices so as to lessen the burden of the justices and to produce the judgment that will set out definitive law of the country. Over the years, many sections of the legal profession and other stakeholders have given some thought to the desirable end of reducing the workload of the Supreme Court and seeing how it can be actualized. But no appreciable progress has so far been made. It has been noted that the Supreme Court of a country is not a court of factual disputations or a court of experimentation. A Supreme Court, as the ultimate court in the country, is a court for the declaration of what the law is at any particular time in the country. If our Supreme Court considers this point as a central core, then of course, they will not have to be saddled making decisions on facts or expressing beliefs or not. In the United States and Canada, the Supreme Court is not a court to rehear cases on appeal and making findings of fact of I believe or I do not believe. Findings of fact are matters for the trial courts at first instance. Whether the trial court is right in its finding of fact and whether the law was correctly applied to facts correctly found is a matter for the Intermediate Court of Appeal. The Nigerian Supreme Court should not be playing the role of Intermediate Courts of Appeal instead of its core role as the Supreme and Ultimate Court of the land. The role of the Supreme Court as the Ultimate Court of the land is and should be that of authoritative declaration as to what constitutes the law on issues adjudicated upon by the trial court and the Intermediate Court of Appeal. The Supreme Court should not be involved in making findings of fact, which the trial court and the Intermediate Court of Appeal have already considered and resolved. For the way out, there are many options, but I think two are important. Let me first rule out one. We are not going to solve the problem of overwork and overloaded dockets by the appointment of additional Supreme Court justices. That will just aggravate the situation and may even lead to conflicting judgments of the Supreme Court, which for now, thank God, we have not got. Those who read the law reports will attest to the fact that the number of conflicting judgments of the Court of Appeal is sufficient to dissuade the judiciary from asking for increase in number of justices. What then should be the remedy? The citizens' right to appeal to the Supreme Court as of right should be reviewed and be limited to, one, constitutional dispute states and federal governments or between governments and citizens where the complaint rests purely on the Constitution and a statute. Dispute two, dispute as to violation of fundamentally entrenched rights under the Constitution. C, cases of disputes on title to land in respect of which there's conflicting decision of the Court of Appeal or the Supreme Court in respect of which there has been no judicial pronouncement or where there's no judicial pronouncement by the Supreme Court. D, disputes as to the legality, validity, and constitutionality of enactments by states, houses of assembly, and by local government councils where no evidence is required. E, conflicts of law made by the states and the federal legislative houses. All these disputes between citizens, whether corporate or human or government, should end in the Court of Appeal in the same way as election petitions other than governorship and presidential as we have now. This is a first step. The ground for the, let us consider the ground that account for the increase in appeal to the Supreme Court. That has to do with the constitutional structure of our Intermediate Court of Appeal. Let me go back memory lane and say that at the time the Court of Appeal was created, little attention seems to have been paid to the necessity to ensure that intellectual content of judgments of the Court of Appeal should rise above that of the trial courts and be equal to or very near the standards of the judgment of the Supreme Court. On the points of law based on accepted evidence in the case, many of the recent decisions of the justices of the Court of Appeal justify some appeals to be made to the Supreme Court. If such judgments had attained the required standard, even a litigant who lost in the Court of Appeal can readily appreciate the reason why he lost in such a case. Though some litigants may still insist on taking a gamble to the Supreme Court, a lawyer of honor and distinction can be relied upon to advise his client that a further appeal to the Supreme Court is unlikely to succeed, and so avoid wasteful exercise of energy and cost. The litigant's dissatisfaction with outcome of the Court of Appeal decisions in some cases contribute to the multiplicity of appeals that go to the Supreme Court. If the standards of the appellate court judgments, of the intermediate appellate court judgment, rise to some appreciable standard, litigants may not then insist on going to the Supreme Court for everything. The question then is, how do we tackle this? To address this issue, we have to look at it structurally. We have only one Court of Appeal in a country of 16 states, of 31 states and the FCT. Each state has its own high court and customary court of appeal, and in some cases, and in others, the Sharia Court of Appeal. They decide issues of custom and decide issues of land, of contracts, and so on. These issues are not decided in the Federal High Court, because the Federal High Court is a court of limited jurisdiction, limited to things set out in Section 251 of the Constitution. Therefore, a judge appointed from the High Court to the Court of Appeal, when confronted with a case of taxation or of matters of custom and excise, what will he do? Go back to school? I think not. In the same way, my Lord, a judge who got to the Court of Appeal through the Federal High Court may not, in his 7 to 10 years as a trial court, he may not have touched anything but disputes involving contracts. He may not have touched anything involving disputes about land or proof of title to land. Then he's catapulted from there into the Court of Appeal. And the first case before him is a decision on a land matter that has lasted for 30-something years before coming to the Court of Appeal. What will happen? So when you blame or complain of wrong or erroneous judgments, we should take this fact into account, that judges of the Court of Appeal are appointed based on the experience they have had as trial judges. But when you bring a square peg and put it into a round hole, will it fit? A judge who for 10 years or so in the Federal High Court has not dealt with land matters or contract, you bring him to come and adjudicate on appeal on that. My Lord, we are only punishing. For that, my Lord, we propose the solution this way. And it is not new. My Lord, the Court of Appeal should remain the Court of Appeal to take appeals from federal causes. The matter decided by the Court of Appeal, by the Federal High Court, should go on appeal to the Federal Court of Appeal. Also included in this class is the National Industrial Court decisions, and of course, the court martials. Those ones should go to those courts because they deal with those matters and so have experience in that matter, in those matters, they should go there. Then for the states, states should have their own intermediate court of appeal. I don't want to hear anybody say, no, they will have no money to pay. They will have. The money is there. Nothing can be too much for ensure people get justice in their courts. And so, my Lord, I advocate in this paper, in this speech, that states should be granted the power to establish their own courts of appeal. And the decision of the Intermediate Court of Appeal, based on what I have suggested, my Lord, should be the end. There must be end to litigation. A litigation that goes from court to court, from magistrate court to Supreme Court. It's a disgrace to the legal service of this country. This country has produced eminent judges, not only for this country, but for the world. We have even produced the president of the International Court of Justice. So why must we attempt to leave customary matters to be dealt with by judges who, for 10 years or more, have never done anything about those matters? My Lord, we need to examine this and recommend that states should have their own courts of appeal. A state court of appeal is not lower in standing than any other one. And if your Lordship look at your records, it is the states, it is the Western Nigeria Court of Appeal that produced your colleague, Honorable Justice Kayode Esho, and produced judgments which are still relied on the matters they dealt with. And so, my Lord, let me end this story, this speech with this. I cannot stop emphasizing the need to have the two sets of the Court of Appeal. If we want this court, the Supreme Court, to make pronouncement, democracy and the governance of this country, we will not be doing ourselves any good. We will continue to complain that the Supreme Court is overworked. It is clear that it's truly overworked. My Lord, we know ourselves. The position now is that the overworking of the Supreme Court justices results in the Supreme Court justices looking older than their true age, which is a wrong thing to do. A man who has retired should be able to enjoy what he has worked for all his life. And so, my Lord, I thank you for giving me the chance. Let me end it up with an apology, my Lord, that I did not produce a paper for circulation as I used to do. The reason is this. It was Richard Akinjide, of blessed memory, who used to pass the invitations to me to come and speak on behalf of the Body of Senior Advocates. This year, there was no such invitation. And so I had no invitation to speak. I had no invitation even to attend. But I felt that it is my duty to attend, but not to speak. Finally, when I was to leave home a few days ago, I said, okay, let me just make a small sketch, just in case there's need to. So I made a small sketch and sent it by email to my office in Abuja, hoping to get here early enough yesterday to read it over and effect the corrections. We were stuck at Asaba for 4 hours. Finally got to Abuja at about 5 o'clock. My Lord, that is why I do not have a written paper ready, sir. But all is not lost, my Lord. I will reduce my thought into when I finish correcting it, I will mail it to the court so that your Lordship can see it. So, my Lord, I apologize that I don't have a written. I cannot submit what I have now until I've effected the corrections. So I thank you, my Lord, and I congratulate my new colleagues again. I thank the new president of the bar. I have said what I've said to the senior advocates. They are your members. They have to do what you want them to do in the interest of the profession. My Lord, I thank you very much, my Lord.
I'll now call on Mr. Olumide Akpata to deliver his address.
My Lord, the Chief Justice of Nigeria, Justices of the Supreme Court, my Lords, the former Chief Justices of Nigeria here present, my Lords, kindly permit me to rely on the already established order of protocol. My Lords, it is with utmost delight that I stand before your Lordships today to felicitate your Lordships on behalf of the Nigeria Bar Association on the 2020-2021 New Legal Year ceremony, and to congratulate the 72 eminent practitioners and academics who have been conferred with the distinguished rank of Senior Advocate of Nigeria. It is consistent with the whole nature of the year 2020 that we are marking the new legal year in December, and that we are today celebrating the